Hi, I'm Allie Howell, Trial and Appellate Counsel for the Upper Midwest Law Center, Minnesota's nonprofit public interest law firm that fights for liberty and the rule of law. Welcome back to another episode of Minnesota Law Report, where we update you on important developments on legal issues in Minnesota and tell you about the ways in which we at the UMLC are fighting for you in the courts. Today, we are talking about JayCee Cooper versus USA Powerlifting. USA Powerlifting maintains sex-based categories for the powerlifting competitions it hosts and prohibits men from entering the female-only category. At issue in this case is whether USA Powerlifting discriminated against plaintiff JayCee Cooper, a male who identifies as a female, in alleged violation of the Minnesota Human Rights Act by not allowing Cooper to participate in the women's-only powerlifting category. This month, the Minnesota Supreme Court heard arguments in the case. And here to help me with this update is a great friend of UMLC and sometimes co-counsel, Renee Carlson of True North Legal. Renee, thanks for joining me.
Thank you, Allie. It's great to be here today on Minnesota Law Report. It's always an honor to work with you and your colleagues at the Upper Midwest Law Center. I appreciate that True North Legal and Upper Midwest Law Center have a unique relationship and share a common desire to advocate for Minnesotans across the state against government encroachment. I've been working on this issue, as I've shared with you and others at Upper Midwest Law Center, more on the policy side. And I can remember when government actors said, men will never be in women's sports. They will never take the place of women in women's sports. But here we are today with this case. And also just wanted to note that this is rather personal to me because I have daughters who play sports here in Minnesota. So whatever happens in this case is not just something that I care about on behalf of all Minnesotans, but it's something that is personally relative to our family.
Thank you for sharing that, Renee. And we're excited to get your perspective on this today. It's an important issue for everyone in Minnesota. Let's start with some background on how this case got to the Minnesota Supreme Court. Cooper sued USA Powerlifting after being denied permission to compete in the women's category. According to Cooper, USA Powerlifting engaged in discrimination based on sexual orientation, which is prohibited by the Minnesota Human Rights Act. Sexual orientation in the act was defined at the time Cooper was excluded from the women's category to include having or being perceived as having a self-image or identity not traditionally associated with one's biological maleness or femaleness.
That's right, Allie. And then the district court granted summary judgment to Cooper on some claims, concluding Cooper's evidence is conclusive proof of discrimination based on both sexual orientation and sex. That means that the district court concluded that the act of excluding a man from women's sports competition violates the Minnesota Human Rights Act, and the case did not need to get to a jury. But the Minnesota Court of Appeals reversed. As the Court of Appeals explained, under Minnesota law, USA Powerlifting's action is discrimination based on sexual orientation only if a fact finder finds, as a matter of fact, that Cooper's transgender status actually motivated the decision. There was evidence that USA Powerlifting excluded Cooper from the women's sports division not because of animus, but because of the inherent competitive advantages men possess. So the Minnesota Court of Appeals agreed with USA Powerlifting that the policy was not facially discriminatory and left the ultimate question of whether USA Powerlifting was actually motivated by discrimination based on transgender status rather than Cooper's male biology for the jury.
So Cooper then appealed to the Minnesota Supreme Court. Both the Upper Midwest Law Center and True North Legal submitted amicus briefs in support of USA Powerlifting. Other organizations filed briefs on both sides. Notably, the commissioner of the Minnesota Department of Human Rights filed a brief in support of Cooper, arguing that USA Powerlifting's policy is inconsistent with the protections under the Minnesota Human Rights Act. In our brief, UMLC represented the Independent Women's Forum and Peyton McNabb. IWF is a nonprofit organization that fights to expand women's options and opportunities. Peyton McNabb is an IWF ambassador and college student. During a high school volleyball game, McNabb suffered a devastating injury from a male athlete who identified as transgender. That male athlete powerfully spiked the ball into McNabb's head, and she was knocked unconscious for over 30 seconds. While unconscious, her body twisted into a fencing position, indicating extreme trauma to the brain. Our amicus brief argued that USA Powerlifting has legitimate and non-discriminatory reasons to maintain categories based on biological sex. These justifications have been well recognized in federal law and have allowed for the proliferation of women's sports under Title IX. Requiring female athletes to compete against male athletes would destroy fair competition in women's sports and put women, like Peyton McNabb was, at risk of serious physical harm.
Well, as you mentioned, Allie, True North Legal submitted an amicus brief in this case as well. We represented the National Legal Foundation and the Minnesota Family Council, which is actively engaged alongside True North Legal in public policy advocacy at the state capitol, advancing policies that preserve both women and girls' opportunities in sports, as well as other policies like our work on the so-called Equal Rights Amendment, which threatens not only women, but also people of faith by eviscerating nearly all sex-based distinctions in the law. Our brief makes the argument that Minnesota's anti-discrimination law expressly permits sex-specific sports teams based on biological differences between men and women, and doing so is not discrimination based on any protected category under the law. We draw the court's attention to Minnesota statutes that specifically and expressly state that restricting membership on an athletic team or in a program or event and would not substantially reduce comparable athletic opportunities for the other sex is permissible and arguably required under the law. Minnesota law also makes references to one sex and the other sex in the same statute, so we're left with little reason to infer that the legislature had anything else in mind but to create separate opportunities for female athletes in Minnesota. Not to mention, there are parts of the law that actually mirror Title IX, which was created to give women equal opportunity, including in athletics. It's important for viewers and listeners to remember Minnesota laws making explicit distinctions based on sex were enacted because of the common recognition on both sides of the aisle of the inherent biological uniqueness of women and the need to provide females with their own opportunities. We also argued that the Minnesota case, Goins v. Westbrook, is still good law, despite the plaintiff's strong assertion that it should be overruled. This is an important Minnesota Supreme Court case in a long line of cases that held that it was not unlawful discrimination when a business relied on sex-based distinctions of male and female when it refused to allow a male who identified as a female the use of the women's locker room. Lastly, we laid out an extensive argument cataloging the clear scientific data about the biological differences between men and women and boys and girls. There really is an inherent difference between men and women, and science has proven this to be true over and over again. That's why we included it in our brief, and we think it's important for the court to consider this as they take a look at this case.
The Minnesota Supreme Court did not give much indication of how it would rule during oral argument. Some of the questions asked, however, do at least signal what the justices may be concerned about. First, some of the justices asked counsel for USA Powerlifting how this case is different than other situations that would be direct discrimination. Justice McCaig asked, how is it any different than if USA Powerlifting had said all Native Americans cannot participate in powerlifting or gay people cannot participate in powerlifting? Counsel for USA Powerlifting pointed out that this case is different because the underlying reason for USA's powerlifting policy is not discriminatory. Instead, there was extensive evidence that men who go through puberty as men obtain significant strength advantages in athletic competition. Moreover, as we argued in our brief, this is not a case where USA Powerlifting announced that all transgender identifying individuals are excluded. Instead, the real sorting method is sex, and males are not permitted in the female category. This type of sorting is not discriminatory to trans-identifying individuals because females, no matter how they identify, participate in the female category. Instead, this case asks whether discrimination, like separate categories, based on biological sex necessarily entails discrimination based on a transgender status. As other federal courts have concluded, the answer is simple. It does not. A policy can lawfully classify on the basis of biological sex without discriminating on the basis of transgender status.
Allie, that's exactly right. And yet, despite the historic advances and gains that women have seen in the law and in society, I was surprised that some of the justices asked questions suggestive and quite critical of female-only opportunities, like female-only sports categories based on biological differences. For example, when counsel for USAPL asserted that USAPL does not discriminate based on gender identity because its categorical distinctions for competition are based on age, weight, and sex, Justice Hennessy interrupted by asking, "What is male physiology? What is meant by that? Is puberty a requisite to determine if someone is male?" I guess you could say, Allie, that Minnesota has its own "what is a woman" moment in this case. It was as if she was suggesting that policing these two distinct categories, male and female, is somehow confusing. Counsel for USAPL responded with a simple and obvious answer stating, "Your Honor, biological birth sex based on your reproductive organs and chromosomes at the time of birth." A very scientific response. These questions remind me of the U.S. Supreme Court cases like United States versus Virginia, where the court held that VMI's male-only admissions policy violated the Equal Protection Clause while also stating physical differences between men and women are enduring and maintain separate accommodations like bathrooms for women who were then admitted to VMI. These were easy distinctions for the court to draw, and they had been drawing them for centuries before this case. The main takeaway from these VMI-type cases is that the court has held that it is permissible for the legislature to take note that biology makes men and women different, and these differences have real-world consequences. They are properly the subject of legislative distinctions within the law.
That's exactly right, Renee. On the other hand, Cooper's counsel argue that these historic distinctions are not important by asserting that, quote, "To the extent there is harm to an individual competitor from allowing another competitor to compete, that's exactly the same as it would be if the sport simply recruited more athletes." Chief Justice Hudson seemed to push back on this point and cited examples provided by some amici of women losing in athletic competition because they were competing against men who have inherent strength advantages. The Chief Justice indicated that this seems to be a, quote, "very real harm to women." Our brief made this exact same point to the court by presenting scientific studies and evidence compiled by the Independent Women's Forum that men have significant athletic advantages to women, and these advantages begin at birth. Men, for example, have larger lungs, larger hearts, are taller, and have greater muscle mass. This sets men up to be better at athletic competition in comparison to women because the female body naturally produces less force when running, jumping, and throwing. These biological differences result in an athletic advantage for men that may start before age 10 and is significant by age 15. The result? Men jump approximately 25% higher than females, throw 25% further, run 11% faster, accelerate 20% faster, punch 30 to 162% harder, and are 30% stronger. And testosterone suppression doesn't create an even playing field. Even if it impairs male athlete performance, the scientific research confirms that it will not come close to reducing male athletic performance to normal female levels. Not only does this result in lost scholarship opportunities and playing time for female athletes, it can also be dangerous, as Peyton McNabb's case shows. Therefore, including male athletes in women's sports acts to exclude female athletes.
The court also asked a line of questions to USAPL about allowing males to participate in female-only sports categories and whether that actually caused real harm to women. As you mentioned, Allie, our brief also mentioned the enormous advantage that male-bodied athletes generally possess over female athletes, particularly when it comes to upper body strength, again, as you also mentioned in your brief, which is certainly relevant to this case and to the activities of USA Powerlifting. Perhaps of more significance is the real-world consequences and the response to males participating in female athletics that we're seeing across the country. I can think of a number of examples where this is happening, but most recently and relevant to USAPL's actions to protect female athletic categories that are consistent with the concerns of at least 4 collegiate women's volleyball teams across the country who have forfeited games because San Jose State is allowing a biological male who identifies as a female to participate on the women's volleyball team. These young women refuse to put their physical health at risk by competing against male-bodied athletes. And this isn't limited to the USA. Around the time that we filed these briefs, the United Nations published a report addressing violence against women and girls in sports, which included an avalanche of findings cataloging the obstacles encountered by female athletes solely because of their female sex, especially when biological men seek to invade their sport. The report corroborates the physical and emotional harms that females suffer when biological men are allowed to compete in women's sports. The report also sheds light on other, often quieted concerns faced by female athletes, such as physical violence, sexual violence, coercive control, and sexual assault, to name a few, resulting from this power dynamic between males and females in sports. From True North Legal's perspective, the recommendations flowing from this evidence are just more weight in favor of USAPL's position to preserve female-only categories in sports.
Thank you for sharing that perspective, Renee. In sum, we at UMLC agree that this is a case with major implications for the future of women's sports. We think this is a case about fairness. When male athletes are allowed to compete in women's sports, we are racing the hard-fought progress for sports equity through Title IX and putting female athletes in physical danger. The Minnesota Human Rights Act, a law about fairness, should not be twisted to require such an unfair result. That's it for this time on Minnesota Law Report. You can learn more about the Upper Midwest Law Center by visiting umlc.org, and you can also make a confidential, tax-deductible donation on our website or by sending us a check to 12600 Whitewater Drive, Suite 140, Minnetonka, Minnesota 55343. And we would urge you to do that. We are fully donor funded and charge our clients nothing. We are standing up for you in court and want to fight for you on every front. Help us do more for you by making a donation today. Thank you, and we'll see you next time.